Okay.
Good afternoon, sir.
Good afternoon. Okay, we'll wait for the others for a bit. We're supposed to be around 40 in the class when we only have 10 here. So maybe they're still coming in. Um, I'll be sending you your attendance form. Copy. Okay, seems like we're already half of the class, so we can start. Um, let's continue with our topic. Um, Let me just share my screen. Okay. All right. So let's continue with this topic on obligations and contracts. So this time, let's go to the pure and about conditions. No, pure and conditional obligations. Um, Whether it's pure obligation or conditional obligation. What does it mean when you say pure obligation, and what does it mean when you say conditional obligation? So a pure obligation is an obligation that is demandable since it has no condition and there is no specific date stated or mentioned. So due on demand siya. Okay? This is an obligation that is demandable at once as stated in Article 1179. That every obligation whose performance does not depend upon future or uncertain event or upon a past event that is unknown to the parties. So no there is no condition in the or there is no stipulation of condition there. So um, the obligation is demandable at the demandable at once, meaning if the creditor wants to collect, they can demand, or they have the right to demand, or he or she has the right to demand the obligation. Okay, as opposed to conditional obligations. So conditional obligations are those obligations that has consequence. One whose consequences are to comply one way or another for its fulfillment. In short, this is an obligation that is subjected to a condition. Thus, the word conditional. So, a condition is a future or uncertain event. A future or uncertain event, upon the happening of which the effectivity or the cancellation of the obligation is subject to it depend, The cancellation of the obligation is subject to it. Okay, depends. So the characteristics of a condition are future and uncertain, and past but unknown. Okay, it could be a future and uncertain, or past but unknown. Also, it must not be impossible. Okay, it should be it should not be impossible, meaning it should be possible to happen. Okay, so but it is uncertain. Okay, but it is not impossible. If it is impossible, it cannot be a condition. Okay, so it cannot be an impossible condition. So it's a future or uncertain event. Future, we all know what future is. Okay, hindi pa siya nangyayari, hindi pa siya nagaganap. Uncertain, you're not sure if the event is going to happen. So, subject to the condition, the obligation can be uh, effective or cancelled. Okay, so that depends on whether it's suspensive or resolutory. Okay, as we discuss later on those items. So, for a condition, it's an uncertain event which wields an influence on a legal relationship. A term or a period that which necessarily must come whether the parties know when it will happen. And obligation demandable at once is for pure obligations, obligations with resolutory conditions, what I've mentioned earlier. So again, let's look at what conditions are. So conditions would be an uncertain event which wields an influence on a legal relationship. So it could um, it could uh, make the obligation effective upon the happening of the certain event. Okay, but that event is uncertain, so you're not sure if it's going to happen, but it's also not impossible. So it's possible to happen, you're just uncertain. And it's going to happen in the future, or it could be in the past, but you don't know what happened in the past yet. Okay? However, a term or a period is that which necessarily must come whether the parties know when it will happen or not. The term or a period is different from a condition because the term is sure to happen. Okay, you are certain that it will happen. An example of this, the very common example for this is death. Death is certain to happen, you just don't know when. So it is a period. Okay, and death is usually a condition for some of the legal contracts that we have, like donations, right? That the donations will become effective at the death or at the time of the death of the donor. Okay, so things like those we call them not as a condition but as a term or a period. So the contract or the obligation is subject to a period. And then there's also this third column that you can see on screen. It says obligation demandable at once, which means that pure obligations, these obligations are demandable at once. One is pure obligations, as we've discussed earlier in the previous slides, and obligations with resolutory condition. So it's demandable at once. The obligation is immediately effective, and it ceases to be effective, or is the obligation is um, terminated, okay, at the time of the happening of the condition. So that's a resolutory condition. Okay. So two principal conditions would either be suspensive and resolutory. When you say suspensive conditions, these are conditions precedent or condition antecedent. Okay, these are conditions which suspend the obligation until the happening of the future or uncertain event. Okay, that's suspensive condition. The demandability of right is after the condition is fulfilled. So when you say suspensive, these are very common, di ba? Maybe your parents will tell you, I will give you a phone if your grades will be will be, say, 85 and above, or 1.25 and above, something like that. So, or your grades is no less than 1.25 on all subjects. So, is it possible to happen? Yes. Is it going to happen in the future? Yes. So, it's a future or uncertain event. It's uncertain because it's not sure whether you'll get 1.25, okay? Unless, of course, you're so confident, no? Um, Marielle, they will have to join, and then I will just admit. I cannot see who's going to if they don't join. So it will prompt on my screen. So if you join, guys, if you join the class, you just join, and then I will see it as a prompt on my screen. You don't have to tell me. I will be able to see it because it's on my screen. Okay. Okay. Again, for suspensive conditions, these are uncertain event. Okay, and in the future. So they have the possibility of happening in the future, but it is uncertain if it is going to happen. And resolutory conditions, okay, suspensive would be a condition that will give rise to the obligation, while a resolutory condition, okay, will extinguish the obligation. What do you mean? So when the condition is going to happen, the obligation is already extinguished. So say for example, I will continue to give you your allowance of, say, 3,000 pesos per month if until until you find a job. So the moment that you have a job, the 3,000 allowance is cut off. So the obligation is extinguished. So that's the difference between a resolutory condition versus a suspensive condition. One is suspensive condition creates the obligation or gives rise to the obligation, while the resolutory condition extinguishes the obligation. Okay, these are conditions that are existing obligation and terminates the right upon fulfillment. So the moment the condition happens or occurs, the obligation is extinguished. That's resolutory. Okay? Suspensive kapag if the condition happens, the obligation arises. So that's the difference. But both of them are also in the future and both of them are uncertain. Okay, so when you say condition, again, it's in the future, and when um, it could also be a past event but is not certain. Is a past event but is still unknown. Okay, or it could be a future or uncertain event. Okay, so remember that, and it's important for you to understand and know what the difference of suspensive and resolutory conditions. So, example of a suspensive condition: Maya binds herself to deliver a determinate car to Tito if he marries Gaia. So, is it possible for Tito to marry Gaia? It could be possible, but it is going to be in the future. So the obligation is only demandable upon the happening of the condition, and that is Tito marrying Maya. The obligation is suspended and not yet demandable. That's why we call it suspensive, because the obligation is suspended until the condition happens. Okay, so the other example is for the resolutory condition. So for example, Arvin binds himself to lend his car to Ian until the latter passes the CPA board exam. So the obligation to lend the car is immediately and demandable at once. Okay, Ian's right over the car is extinguished upon his passing the CPA board. Ian is now obliged to return the car after he passes the CPA board. Is it possible for Ian to pass the CPA board exam? Yes, it is possible, and it's going to be in the future. Okay, so that's an example of resolutory condition. Follow so far?
Yes, sir. Yes, sir. Yes, sir.
Yes, sir.
Okay.
Sir.
Okay. Then we also have potestative, casual, and mixed conditions. Okay. Potestative conditions is condition, okay, suspensive condition in nature and which depends upon the sole will of one of the contracting parties. When a suspensive condition is upon the will of the debtor, the conditional obligation is void because the validity and the compliance is left upon the debtor. So parang may possibility na hindi magkakaroon ng na there will be no point na magiging due and demandable yung obligation because of the provision that it depends upon on the debtor. So it's going to be void kasi dapat hindi siya solely dependent on the debtor's will. Okay. So remember that if the suspensive condition is solely upon the will of the debtor, then the conditional obligation is void. Okay, so that's a potestative condition. Okay, again, is dependent upon the will of one of the sole will of one of the contracting parties. So it's potestative again, potestative. So potestative on the part of the debtor, suspensive is both condition and obligations are void for being a sham or parang scam. Bakit si debtor ang magdidictate kung kailan siya magbabayad? So, example, I will give you my car next year if I don't want it anymore. So pwede lang yan sabihin na gusto pa niya yung car. So, it may not happen. Okay, so potestative on the part of the debtor is void. So, resolutory, valid. Okay. Example, I am hiring you now as the manager of the restaurant I am establishing, but if all the furniture I ordered from abroad does not arrive by next month, your employment is terminated. So, it is valid. Okay. The obligation to hire the manager is immediately demandable at once, but once the condition happens, the obligation is terminated. So that's a valid one. Okay, but this one, this one, it gives rise to the obligation immediately and terminates upon the will of the one of the parties. So it's potestative, but at the same time, it gives rise to the obligation immediately because it's resolutory and therefore it's valid. For this one, according to Article 1182, when the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation is void, as I've mentioned earlier. Second is that only if the condition is void, there is a pre-existing obligation and hence does not depend for its existence upon the fulfillment of the debtor or the potestative condition, therefore leaving the obligation unaffected. While if the suspensive condition is upon the will of the creditor, the obligation is valid. If the suspensive condition is upon the will of the creditor, again, the obligation is valid because it will give rise to the obligation becoming due and demandable. So example, for potestative on the part of the creditor, it's valid. I will give you my notes if you want them. I will give you my 500 if I can sell my iPhone. Okay, so that's valid. Okay. Potestative condition. Okay, if the resolutory condition depends upon the will of the debtor, the obligation is also valid. Okay, because it will just give rise to the termination of the obligation. In Article 1181, the fulfillment of the condition causes the extinguishment of the acquisition of rights already acquired. Also, the debtor is not really interested in it, so it's valid. Casual condition, if the suspensive condition is uh, upon chance. Um, so for casual condition, if the suspensive condition is upon chance or the will of a third person, the obligation is subject. Subject is valid. Okay. Casual, it's upon chance or the will of a third person. The obligation subject is valid if it is depending upon the will of a third person. Okay, and then there's also the mixed testative conditions. Um, if the suspensive condition depends partly upon chance or partly upon the will of a third person, then the obligation is valid. Okay. So example, X obliges himself to repair Y's house at X's expense. Any damage that may have caused to the building by earthquake occurring within 8 years from the date of completion of its construction. So this is um, depending upon the will of a third party. No? So that may have caused to the building by earthquake within 8 years. So X obliges himself to repair the house at X's expense. Any damage that may have caused to the building by earthquake. So casual condition again is one which depends upon chance and not in the power of the creditor. So this one, is there a chance to have that there will be an earthquake? Yes. And within 8 years that it will occur? Yes. So the suspensive condition, the casual condition, it is suspensive because the obligation does not come until the happening of the event. So it's suspensive. And then it is casual because it depends upon chance. So in here, the obligation arises, okay, upon the happening of the earthquake and there's any damages, then X obliges himself to repair the house of Y. So that is an example of casual condition. For mixed conditions, we have this example. Manuel promised to give Montalban a Mexican guitar if he is accepted supervisor of MCDC construction company. It can be seen that the condition here depends partly upon the will of the obligor and so also partly upon the will of MCDC construction company, the third party. So the third party is involved and therefore partly, so this is a mixed condition. Even if he applies as supervisor, the company may not hire him. So there is still that factor for MCDC to decide to accept him, okay, or to hire him. So this is an example of the mixed condition. What are examples of impossible conditions and its impact? So impossible conditions, those contrary to good customs or public policy and those prohibited by law, shall annul the obligation which depends upon them. If the obligation is divisible, that part thereof which is not affected by the impossible or unlawful condition shall be valid. So yung part lang mostly would be yung part of the obligation with an impossible or unlawful condition will be invalid or null. But if the obligation is indivisible, then the entire obligation is void. The condition not to do an impossible thing shall be considered as not having been agreed upon. Okay? The condition not to do an impossible thing, okay, is as if there is no agreement. Okay, that's what it's saying. Why would you agree to have to not do something that is already impossible in the first place? So of course you cannot do it because it's already impossible. So why would you have to agree on that? Okay, so um, that's for impossible conditions. So two kinds of impossible conditions would be physically impossible and legally impossible. When you say physically impossible, these are in nature, in things which cannot exist or cannot be done. Okay, because the laws of physics and science dictates it, or physically is impossible. Like you have to be physically present in the meetings happening at the same time in both New York and London. So how can you do that? You only have one body, so that's physically impossible. However, legally impossible conditions, these are could possibly be physically possible, but is not allowed under the law, moral, good customs, public order, or public policy, and still therefore legally impossible conditions. Okay, so again, for impossible conditions, we have two physical and legally impossible conditions. What are the effects of the conditions that is impossible or that are impossible? Conditional obligation is going to be void. Impossible conditions annul the obligation. Both obligation and the condition are void, as the obliger knows his obligation is not legal or cannot be fulfilled. Hence, the obliger has no intention of complying with his obligation. Okay. While conditional obligation is valid if only the condition is negative or not to do an impossible thing, therefore the obligation is rendered pure and valid. Okay? So if only the condition is negative or not to do an impossible thing, therefore the obligation is rendered pure. Pure meaning it's demandable at once, and valid. Why? Because it's as if there is no condition. Okay? Example, conditional obligation is void. Example will be, I will give you 300 pesos if you kill X. Both conditions, kill X and obligation give 300, are void. If the condition is negative or not to do the impossible, the condition is disregarded, but the obligation is valid. So if we tweak the example above and say, I will give you 300 if you do not kill X. So killing X is legally impossible because is illegal, and therefore it's as if there is no suspensive condition, and therefore the obligation is valid, and that obligation is pure, meaning the obligation to give the 300 is demandable at once. Okay. So conditional obligation is valid. I will give you 300 if you jump over the moon. Okay. So in this case, disregard the condition, jump over the moon, but the obligation to give 300 is still valid. It becomes pure obligation. We'll just disregard the condition. Okay, so effects of impossible conditions. Only the affected obligation is void. Okay, if the obligation can be divided, the part where the impossible condition is not affected shall be valid. Okay, and then there is also that only the condition is void if the obligation is pre-existing, therefore does not depend on the fulfillment of the impossible condition. Hence, only the condition is void. Okay. Just- Sorry, guys. I'm just interesting. Just have to. Sorry about that. Okay. Okay. So only the condition is void if the obligation is pre-existing. Okay. So if the obligation is already there and it just so happened that a condition is being imposed, then the condition that you have imposed is impossible. The effect would be that the obligation is still valid, but the condition is deemed to be void, and therefore it becomes demandable, becomes pure. Okay. So in Article 1186, the condition shall be deemed fulfilled when the obligor voluntarily prevents its fulfillment. So, big sabihin, if you're the obligor and you prevent the condition from happening so that the obligation, okay, will not be the obligor voluntarily prevents the fulfillment, meaning you wanted to prevent it from happening so that the obligation does not become demandable. So that is going to be rendered constructive fulfillment of the suspensive condition. Okay. And therefore, it gives rise to the obligation as if the condition already happened. Okay. So constructive fulfillment of suspensive conditions would be either of the three, would have all these three requisites for the application of this Article 1186. Okay, that the condition is suspensive, the obligor actually prevents the fulfillment of the condition, and he acts voluntarily. So the law does not require that the obligor acts with malice or fraud as long as his intention is to prevent the fulfillment of the condition, then the condition is deemed to have been fulfilled and therefore it gives rise to the obligation. Okay. For example, Paula promised Nicole that she will give her an iPad if Pauline sings inside the classroom on Wednesday. On Tuesday night, Paula gave Pauline a bucket of peanuts knowing that the latter is allergic to it. Okay? So, what happens if Pauline was not able to perform in class because of her allergies? There is constructive fulfillment. Why? Because Paula intentionally prevented, voluntarily prevented, and knowingly prevented Pauline from being able to perform in the class, okay, by giving him a bucket of peanuts, which is uh, Pauline's allergy, so or will trigger the allergies of Pauline. So in that case, Paula is trying to prevent the condition from happening. And therefore, according to the law 1186, it is deemed to have been fulfilled. That's what you call constructive fulfillment. Okay, you try to sabotage the happening of the condition in order for you to avoid your obligation from being demandable. If that's the case, that is constructive fulfillment. Next example, Me binds herself to deliver a determinate car to Lester if he marries Wina. The obligation is demandable upon the happening of the condition, that is, Lester marries Wina. The obligation is suspended and not yet demandable. Okay, so it's waiting upon Lester's marriage to Wina. Okay, so retroactive effects of fulfillment of suspensive conditions. What is the effect if the condition set upon in the obligation will actually happen? So in obligations to give, this becomes demandable only if the condition is already fulfilled. However, once it is fulfilled, its effects will retroact to the day when the obligation was constituted. Because the condition is only an accidental element of a contract and the obligation can rise without being subject to a condition. So, example, on January 1, 1999, A agreed to give B a parcel of land if he passes the May 1999 CPA exams. If B passes the CPA exams in May 1999, he is entitled to the land effective January 1, 1999 because B's right over the land retroacts to the date when the obligation was constituted. Okay, so in to do or not to do, the rule is that there is no fixed rule provided. However, this does not mean that the principle of retroactivity is not applicable. The courts are empowered by the use of sound discretion and keeping in mind the intent of the parties to determine in the cases which the retroactive effect of the suspensive condition has complied with, in to do or not to do. Because but in to do, it's impossible for you to go back in time and do something, right? So it is upon the courts to decide what will be sound, okay, what will be the practical and reasonable and just and fair, okay, decision whether or not to retroact. In reciprocal obligations, no retroactivity takes place because the fruits and interests upon the condition are deemed to be mutually compensated. The rule is necessary for the purpose of convenience since the parties would not have to render mutual accounting. In unilateral obligations, there is usually no retroactive effect since they are gratuitous. The debtor does not receive anything from the creditor. So, example of reciprocal: A agrees to sell and B agrees to buy A's parcel of land if B passes the May 1999 CPA exams. If B passes the May 1999 CPA board exam, the obligation becomes demandable. B is entitled to all the interests that his money with which to pay A may earn, while A is entitled to the fruits which the parcel of land may have produced during the pendency of the condition. So again, as we've said earlier, in reciprocal obligations, no retroactivity, okay, so that you don't have to render mutual accounting. So in this case, compensated, turn over lang niya yung money and then turn over yung land. In unilateral obligations, X agreed to give Y a parcel of land if Y passes the CPA board in May 1999 exams. Pending the happening of the condition, X is entitled to the fruits which the land may produce. X will deliver only the parcel of land if the condition is fulfilled, unless a contrary intention appears. So, in this case, in unilateral, there is no retroactivity as well. Okay, X is going to just entitled to the land may produce. Okay, X will deliver only the parcel of land if the condition is fulfilled. Example, in 2010, Joshua promised Alvin that he will sell his car for 100 if Chris becomes the student council president on year 2012-2013. In July 2012, Chris became the student council's president. Therefore, Alvin's right to compel Joshua to sell the car began in 2010. So, rights of creditor pending fulfillment of suspensive condition in Article 1188, Paragraph 1, the creditor may, before the fulfillment of the condition, bring the appropriate actions of the preservation of his right. Okay? Bring the appropriate actions for the preservation of his right. So, kung sa tingin ni creditor na mga nganib yung rights niya over the property at hand in the obligation, then he or she may bring action for the preservation of his right. The right of the creditor is he or she may take appropriate actions for his right as the debtor may not render the importance of the obligation upon the happening of the condition. So, therefore, he may take it in court to prevent the hiding of the property the debtor has to deliver or to have his right annotated on the title of the property in the registry of deeds. Okay, so pagka medyo nanganganib din, ipa-attach mo or ipa-annotate yung property so that it cannot be easily conveyed or transferred or hidden from you. Okay, so how about loss, improvement, deterioration of things to be delivered pending the fulfillment of suspensive conditions or resolutory condition? So in 1189, when the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. Okay, what are those rules? One, loss of things without debtor's fault, the obligation is extinguished. In general, a person is not liable for a fortuitous event. Okay. Two, loss of things through debtor's fault. If the loss is due to negligence, the creditor is entitled to demand for damages. Three, deterioration of a thing without debtor's fault. Okay, when its value is reduced or impaired, in this case without the debtor's fault, therefore the debtor is not liable for the damages, and the creditor will have to suffer from the deterioration. Okay, how about if things that deteriorate through the debtor's fault? There are two choices to choose. First, the rescission or cancellation of the obligation with damages. The debtor is liable to pay for the thing and the incidental damage due to the deterioration. Or second is to fulfill the obligation and also to pay the damages. Okay. Next, rule improvement of things by nature or by time. So if there is improvement or it's increased in value or enhanced by nature or by time, okay, in this case, the creditor gets the benefit of the improvement. How about if at the expense of the debtor, then the debtor is having the benefit of improvement while using the thing belonging to another. Okay, so improvement of things at the expense of the debtor. In this case, the debtor is having the benefit of improvement while using the thing belonging to another. So, meaning usufructuary na lang ang benefit na nakukuha niya. Yung usufructuary rights over the property while it is being improved is going to be the compensation for the expense that the debtor actually incurred in the improvement of the thing. How about the effects of fulfillment of resolutory condition? So in resolutory conditions, of course, if the condition has happened or occurred, then the obligation is extinguished. The parties are obliged to return to each other what they received under the obligation. And in addition to any obligation to do or not to do, the courts shall determine the courts shall determine the retroactive effect of the fulfillment of the resolutory condition. The courts may even don't allow retroactivity in each case. So an obligation to give, there is a return to give, there is a return to the status quo, meaning balik na lahat, okay? Whatever they owed or have exchanged will be returned because the obligation has been extinguished. The effect of the fulfillment of the condition is retroactive. The obligation of mutual restitution is absolute. It applies to the things received as well as to the fruits and interests. In case the thing to be returned is legally in the possession of a third person who did not act in bad faith, the remedy of the party entitled to restitution is not against the third person, but the other. Again, in the case the thing to be returned is legally in the possession of a third person who did not act in bad faith, meaning he is in good faith for receiving and having possession of the item or the thing that needs to be returned, the remedy of the party entitled to restitution is not against the third person, but the other, meaning to the original contracting party that he or she has contracted with. The third party cannot be held liable for the thing that he acquired in good faith. Okay, in obligations to give, subject to a suspensive condition, the retroactivity admits of exceptions according to whether the obligation is bilateral or unilateral. Here, there are no exceptions, whether the obligation is bilateral or unilateral. If the condition is not fulfilled, the obligation or rights acquired by a party become vested. Sa kanya na because the condition did not happen. Okay? So the fulfillment of resolutory condition moves the creditor to debtor and vice versa. Therefore, there will be an applicability of the provisions of 1189 in case of loss, deterioration, or improvement of the thing. Okay? Pending the fulfillment of the condition, the debtor and the creditor are entitled to the rights of of each other in under Article 1188. Okay, so how about the kinds of obligation according to persons obliged? So for unilateral, there is only one party that is obliged to comply with an object or prestation, while in bilateral, both parties are obliged to comply with each other. Both are debtors and creditors of each other. It can be reciprocal obligations or non-reciprocal obligations. For reciprocal obligation, this means that this is an obligation which arises from same cause and both parties are debtors and creditors to themselves. This is an act wherein the performance of the debtor is equivalent to the performance of the creditor and vice versa. Non-reciprocal obligations are those that do not impose that the performance of both parties are simultaneous and correlative. The performance of one party do not depend upon the simultaneous performance of the other party. So, hindi siya yung sabay kayong magbibigay, okay, or fulfill ng obligation. That's just what non-reciprocal obligation is. So, what are the effects of mutual breach? In pari delicto kayo, no? As mentioned in Article 1192, the case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall bear his own damages. So kung pareho naman kayong may mali, pareho din kayong mag-bear ng mga losses or damages nyo. Pareho kayong may mali eh. Okay? So, he who goes to courts must come with clean hands. Yun yung sinasabi nila. Okay? So, if you're in pari delicto, it's just so hard for the courts to favor one if you are both at fault. Okay? But of course, there is this rule on first infractor. If you're the first infractor, okay, it shall be equitably tempered by the courts. So, in 1192, contemplates two situations. First, infractor known. So, if the first infractor is known, if one party violated his obligation, afterwards the other party committed a violation also to his obligation. In result to that, the first infractor's liability should be equitably reduced. Kung hindi lang sana nagkaroon ng infraction, hindi rin nagkaroon ng violation si other party, yung second infractor, then he could have claimed damages for the whatever damages he suffered or losses he suffered because of the infraction of the first infractor. But since pareho silang may mali, the first infractor's liability, yung damages will be lessened, mitigated, reduced equitably by the courts according to their discretion, wise discretion or sound discretion, because the second infractor is also a violator or a breacher of contract. So, a first infractor cannot be determined. Both of the parties violated their obligation subsequently. However, the first infractor cannot be determined or recognized. Therefore, the contract shall be deemed extinguished and both shall bear their own damages. Walang pwede kasi kung hindi ninyo ma-determine kung sino talaga unang nagkamali or violated the contract, then sasabihin ng court, okay, both will suffer their own damages. The obligation is extinguished. Okay, so in 1192, it contemplates two situations. In effect, the court shall not provide remedy to the two parties who must suffer the damages allegedly sustained by both parties. Okay, again, kasi you're both at fault. Okay, let's go to the next section, which is obligations with a period. As we have defined earlier, when you say a period, it is certain to happen. It will go in the future, but it is certain to happen. So that is a period or a term. Okay, so obligation with a period under Articles 1193, obligations for whose fulfillment a day certain has been fixed shall be demandable only when the day comes. Okay, so a period could also be a specific date, like I will give you 500 pesos come October 31, 2021. So that's a period. Obligations with a resolutory period take effect at once but terminate upon arrival of the day certain. So I will continue to give you like a condition that will say, I will continue to pay you 20,000 pesos per month until the end of the semester. So that is a resolutory condition because the obligation uh, immediately started at the time that the contract is signed. However, it will be terminated at the end of the semester, which is certain to happen. Okay? A day certain is understood to be that which must necessarily come, although it may not be known when. If the uncertainty consists in whether the day will come or not, the obligation is conditional. Okay? And it shall be regulated by the rules of the preceding section. Because this one, it's resolutory condition. If it is, if it is, um, sorry. If the uncertainty consists in whether the day will come or not, the obligation is conditional, not with a period. When you say conditional, it could be, it could happen or it may not happen. Okay, so there is a possibility, but it is not certain. Then that is a condition. If it is certain to happen, then it is a period. Okay, but 1193 only deals with a period. So period and term have the same meaning and are used interchangeably. It consists in a space or length of time upon the arrival of which the demandability or extinguishment of an obligation is determined. So a period is certain length of time which determines the effectivity or the extinguishment of the obligations. Yes, Claudine? You want to say something, Claudine?
Nothing, sir.
Okay. A day certain is understood to be that which must necessarily come, although it may not be known when. And on or about may be 2 or 3 days before or after the date mentioned, but not so remote thereafter. Okay, so pagka ang ginamit na period or term is on or about, it could be construed to be around 2 or 3 days before or after the date mentioned, but not so remote thereafter. So hindi naman pwedeng 2 months before, it's not reasonably on or about. Or it cannot be like 5 years after. No? So on or about would be around 2 or 3 days before or after that date. So period distinguished from a condition. In their fulfillment, a condition is an uncertain event, but a period is an event which must happen sooner or later. Okay? At a date known beforehand or at a time which cannot be determined. With reference to time, a period always refers to the future. Okay? A condition may, under the law, refer an event to the past if it is an event. As to influence of obligation, a condition causes an obligation to arise or to cease. Okay? To cease. But a period merely fixes the time or the efficaciousness of the obligation. It is true that a period may have a suspensive or resolutory effect, but in the former, it cannot prevent the birth of the obligation in due time, and in the latter, it does not militate against its existence. Okay. So, what are the requisites for a valid period or term? It must refer to the future, okay, and it must be certain, sure to come, but can be extended, and it must be physical. It must be physically and legally possible. Otherwise, the obligation is void. So there are kinds of terms: suspensive, of course, suspensive term, suspensive period, XD, and resolutory period, Indian. XD, a term or period with a suspensive effect, which means the obligation becomes effective only from the arrival of a certain date. And resolutory period, Indian, term or period with a resolutory effect, which means the obligation again will subsist up to a certain day, and it terminates upon the arrival of that day. Okay, as I've given examples earlier. So, for suspensive period, example, Joey promises to support Rachel from the death of Rachel's father, which means the obligation only begins from the death of Rachel's father. In resolutory period, Joey promises to support Rachel until Rachel reaches her majority age, which means the obligation is already effective, but it will terminate once Rachel turns 18. Okay, so that's the difference. One is already demandable at once at the start, but the other, in suspensive, the obligation can only be demandable at the time of the happening of the condition or the period, or at the arrival of the period. So, effects of a period, obligations with a term are demandable only when the day fixed for their performance arrives. Thus, in actions for the recovery of debts payable in installments, those not yet due and payable cannot be demanded in the complaint. Okay, those not yet due and payable cannot be demanded in the complaint. Of course, kasi hindi pa naman siya due. Okay. So, when do courts fix a period? So, the court may fix a period when there is no fixed period, but it can be inferred that the period was intended by the parties. Parang hindi lang siya expressly nakalagay dun sa contract, pero there was an intention based on the letter of the content of the contract. There was an intention to set the period by the parties from its nature and the circumstances. So when the duration of the period depends upon, it's also, so that's one case where the court may fix a period, meaning court ang magsasabi kung kailan. And then another instance where the court may fix a period is when the duration of the period depends upon the sole will of the debtor. Sabihin ni court, oops, hindi pwede yung period na yan kasi it depends upon the will of the debtor. That's potestative will of the debtor. It's void, so we have to fix that. In determining a period, the court aims to enforce the intention of the parties not to modify the obligation, and to prevent the possibility of breach of obligation. Hindi naman yung pwede, hindi na siya kailangan magbayad dahil hindi naman siya magiging demandable. No? So, to prevent the possibility of the breach of the obligation. And therefore, the courts may come in to fix the period. Because again, if we go back to our previous discussions in the previous meeting, we said that there is freedom to stipulate in contracts and in obligations. But of course, the courts may come in if it means to fix a period. Okay, so and these are the aim. Okay, the aims of the courts when they fix a period. One is to enforce the intention of the parties, and two, to prevent the possibility of breach of obligation. Okay. So, what are or how is a complaint for right of action be supported by? The facts showing or inferring that the period for the performance of obligation was intended by the parties, and the facts showing that obligation is favorable to one party but forced upon unfavorably to the other. Parang nagiging dehado yung isa. Because remember, when a contract is drafted, it is a protection for both parties. It hindi pwede yung it only favors one person. Okay. So, when courts may fix a period, again, such complaint must expressly ask for the court for a period unless the facts are sufficient to show the need for such right of action. So a period cannot be fixed by the court if such period is agreed upon by the parties and has already lapsed or expired, or if such period has already previously fixed by the court with the consent and acceptance by the parties. Okay. However, the parties may create a new period under a new agreement. Okay. So technically, the courts will not just intervene. Okay. They respect the sanctity of the contract between the parties. So, benefit or use of the period, the debtor shall lose every right to make use of the period. When he becomes insolvent, assets is now less than liabilities or unable to pay his debts as they mature unless he gives a sufficient guarantee or security for such debts. Okay? So, ano ibig sabihin yan, sir? Because the fixing of the period is again for the benefit of both parties. So, pero sinasabi dito sa provision na to in this particular provision of the law that the debtor can actually lose the right to enjoy the period when he becomes insolvent. Kasi syempre, if you're the creditor, magtatanong ka din, mabayaran ba ako pagdating ng period na yan? I-insolvent na nga yung person, di ba? So the debtor shall lose every right to make use of the period, and therefore the obligation can be demandable at once. It becomes pure obligation. Okay, another case is when he does not furnish or provide the guarantees or securities promised to the creditor. So kung meron dun sa that I will enjoy this period, di ba, babayaran ko after 5 years, pero hindi ka, with the guarantee or collateral, example, titulo ng lupa, and then you did not give the titulo ng lupa, then that will give rise to your obligation at once. Hindi na siya subject to the suspensive period because you did not comply with the guarantee or security you promised to the creditor. The creditor has the right to demand the obligation. Okay? So, again, when the guarantees or securities promised are either impaired due to his fault or negligence or have disappeared or lost due to fortuitous event unless immediately replaced with something of equal value. So, again, dito, the debtor shall lose their every right to make use of the period if the guarantees or securities promised are either impaired or have disappeared or lost. Kung nawala or, di ba, na-destroy. Example, yung guarantee niya is car, tapos yung car niya is nasira or nasunog or whatever, it has been deteriorated in value, he has to provide another security or guarantee of equal value. Otherwise, he will lose the benefit of using the period. Another way to lose the benefit of using the period is when he violates any undertaking that are taken into consideration in the agreement to the period by the creditor. So, of course, dahil may ginawa siyang kalukuhan against the agreement or not in consonance with the agreement, then he or she should suffer the consequence. The obligation becomes due and demandable again. So, another way to lose that benefit of using the period is when he attempts to abscond or escape the obligation secretly. Nagpaplano na pala siyang lumayas ng Pilipinas, di ba? So, kapag na-discover ni creditor, hindi na siya maghihintay ng after 5 years. Sabihin niya na, ano ka ba? Takas ka pala. So, bayaran mo na, di ba? So, you will lose the benefit of using the period because, again, the assumption of setting the period in the contract, in the obligation, is really that it will benefit both the obligor and obligee or the debtor and the creditor. Pero hindi naman yung madedehado na masyado si creditor, di ba? So, that's the case when he attempts to abscond or escape the obligation secretly, then that's another way for you to lose the benefit of using the period. Okay? In such cases, the period is extinguished and the obligation becomes, as I've said earlier, it becomes pure and hence demandable at once. Okay. So, because sabi nga natin, if there is a suspensive period, the obligation is not yet due and demandable until the arrival of the period. However, if these things happen, there are violations, the guarantees is deteriorated, or all other stuff that we have just discussed, will happen or has happened, then the obligation becomes pure. Okay? Kasi kung hindi siya pure, ano nga siya? Conditional obligation siya. Meaning there is still some conditions that needs to be fulfilled or a period has to arrive in order for the obligation to be demandable or will give rise to the obligation. But since this happened, it will become pure and hence demandable at once. Okay? So those are about the obligations and conditions and period. relating to obligations. Let me just share to you this verse before we take a break. Okay. Do not pervert justice. Do not show partiality to the poor or favoritism to great, but judge your neighbor fairly, like when you agree on certain obligations. All right. Thank you and God bless you all. I'll see you in a bit. We'll just take a 5-minute break, 5 to 10 minutes break, and then we'll proceed to the next topic. All right.
Okay,
Yes, sir.
Okay.
Okay, sir. Okay po. Okay, sir.